Hi, this continuing education program is entitled Sexual Harassment Prevention, Standards, Responsibilities, and Enforcement. It's brought to you by the Illinois Council of Health System Pharmacists. My name is Sharon Karina, and I'll be your presenter for this activity. This training will fulfill the Illinois license renewal requirements for pharmacists and pharmacy technicians. To begin, I do not have any conflicts of interest to disclose. These are our learning objectives. We're going to define sexual harassment under the Illinois Human Rights Act and distinguish it between unlawful conduct, inappropriate workplace behavior, and protected categories. We'll also identify conduct that constitutes unlawful sexual harassment. We'll be discussing federal and state statutory provisions for victims, and we'll summarize employer responsibilities for sexual harassment prevention, investigation, and corrective actions. So why does this matter in healthcare settings? Healthcare settings are characterized by strict hierarchies, like pharmacists, technicians, residents, students, and patients, and can create conditions where harassment is less likely to be reported. It's important to emphasize that the Illinois Human Rights Act compliance is required as well for Illinois professional license renewals. In this section, we're going to cover the IHRA definitions of sexual harassment, protected categories, and important distinctions between unlawful conduct, inappropriate behavior, and protected status. So what is sexual harassment? Sexual harassment is any unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. There are 5 main forms of sexual harassment. It's not limited to physical contact. It can also include verbal, written, visual, and digital conduct. The key threshold is that the conduct must be unwelcome and sexual in nature. The legal definition of sexual harassment is on this slide. It's important to note that Illinois law is significantly broader than federal law in 2 key ways. So between these 2 columns, the federal law applies to employers with 15 or more employees, and federal employees, managers, peers, and non-employees, versus Illinois, which applies to all employers, even with just 1 employee. In addition, a single severe act may be sufficient to constitute harassment under Illinois law, whereas federal law typically requires severe or pervasive conduct, and we'll go over that a bit more later. You will note that I did put gender identity in red with a question mark. We will discuss this further in just a few slides, but in January of 2026, the Equal Employment Opportunity Commission, also known as the EEOC, rescinded its guidance, and that may impact certain LGBTQ+ protections at the federal level. That is not the case in the state of Illinois. If you're not familiar with the legal terminology, there are 3 scenarios that trigger IHRA coverage. One of them is it's used as a job requirement, right? Indirectly or directly. It could affect your job opportunities, or you feel it may affect your job opportunities if you don't submit to it. Or it makes your work environment unbearable, meaning it's so frequent and so serious that it gets in the way of you doing your job, or it makes your workplace feel threatening. The EEOC is a federal agency responsible for enforcing Title VII and other federal anti-discrimination laws. Employees typically must file a charge with the EEOC before they can pursue a federal lawsuit. And the EEOC then investigates, mediates, and can file lawsuits on behalf of employees. In January of 2026, the EEOC voted to rescind its prior enforcement guidance that it previously provided to employers. The rescission removed language that specifically addressed LGBTQ+ protections, including misgendering and bathroom access. However, legal experts do note that the Bostick versus Clayton County Supreme Court decision in 2020 still remains a valid precedent. And if that is still the case, then Title VII would protect gay and transgender workers from discrimination. In contrast, Illinois law provides independent, broader protections. While the EEOC's current 2026 guidance only addresses the binary sex and same-sex harassment situations, Illinois law explicitly and broadly protects sexual orientation and gender identity or transgender status. Both sets of these protections can apply simultaneously. It's important to understand what constitutes unlawful conduct that triggers legal liability under the IHRA. So some examples of this for unlawful conduct are quid pro quo harassment, severe or pervasive hostile work environments, sex-based discrimination, and retaliation for reporting. In contrast, inappropriate behavior violates company policy and can result in disciplinary action, but it may not meet the legal threshold of sexual harassment. Some examples of this include offensive jokes not severe enough for legal thresholds, unwelcome but isolated comments, unprofessional conduct or rudeness, and any behaviors violating workplace policies. Protected categories are the characteristics upon which a harassment claim must be based. So the protected categories under IHRA include sex and gender identity, sexual orientation, pregnancy and childbirth, and any sex-based characteristic. Employers have to address all three of these columns, but for different reasons that we'll explore later in the presentation. Conduct can cross from inappropriate to unlawful in a few different ways. First, the behavior must be unwelcome. It also must be sexual in nature, and it must be severe or pervasive. So for example, power dynamics, like a supervisor over their subordinates, can lower the severity threshold because of that inherent power imbalance. A single severe incident like assault can be unlawful versus repeated less severe incidents that together create a hostile environment. These are some key categories of unlawful conduct. Any of these can meet the legal threshold depending on the context, frequency, and severity. The next slides will go into some detail on each of these categories. Verbal harassment is often the most common form. It includes not just explicit sexual comments, but also repeated unwelcome flirtations, comments about someone's appearance, and sexual jokes, even if it's framed as a joke. So the important thing to remember is that the person's intent does not determine whether the conduct is harassment. The impact on the recipient or the victim matters. Nonverbal and visual harassment can be easy to dismiss as not a big deal, but displaying suggestive images, making obscene gestures, or staring in a sexualized way can meet the legal threshold, especially when combined with other conduct. Physical harassment ranges from seemingly minor unwanted contact, like a shoulder rub or a lingering hug, to the most serious end, actual or attempted sexual assault, which is automatically unlawful. In small pharmacy spaces where people work closely together, the potential for unwanted physical contact is increased. It's important to understand that someone saying, "I was just being friendly," is not a defense. Digital harassment is increasingly common and may be underreported because people aren't sure if it counts. I'll clarify that conduct through work email, personal texting, messaging apps, and social media can all constitute harassment if it's unwelcome, sexual in nature, and connected to the work environment. Cyber stalking and monitoring a coworker's location or online activity also fall into this category. There's a legal significance between unlawful conduct and inappropriate behavior. This matters because unlawful conduct can expose the employer to either EEOC or IDHR complaints and litigation. Inappropriate behavior must still be addressed by the employer under their company policies, and understanding the difference helps supervisors respond proportionally and consistently. Examples of behaviors that cross the line professionally but may not meet the legal threshold for sexual harassment include off-color jokes, unwanted comments, unprofessional conversations or inappropriate humor, and poor boundaries not tied to sex discrimination. However, just because it's not technically illegal does not mean it's acceptable or that employers should ignore it. Unprofessional behavior that goes unaddressed can escalate into legally actionable conduct. There are some special considerations in pharmacy settings. For example, the technician-pharmacist relationship can mirror the supervisor-subordinate dynamic that amplifies legal risk for quid pro quo claims. Patient or caregiver harassment still requires a response from the employer. And this is because the IHRA protects against harassment from non-employees and places of public accommodation. In addition, small pharmacies may have limited oversight and fewer reporting options. Let's stop and reflect. Illinois law defines sexual harassment as which of the following? A, any workplace conflict between employees that makes someone feel uncomfortable. B, only physical contact of a sexual nature made by a supervisor towards an employee. C, any unwelcome sexual advances, requests for sexual favors, or conduct of a sexual nature that is made a condition of employment, affects job decisions, or creates an intimidating, hostile, or offensive work environment. Or D, harassment that only occurs when there are at least 15 employees in the workplace. Answer C is correct. So remember the three-part IHRA definition of sexual harassment. If it's made a condition of employment, it affects your job decisions, or it creates a hostile or offensive work environment. I'll note that answer D is a common misconception, but Illinois law applies even to employers with only one employee. Here are some key takeaways in this section. Sexual harassment has protected categories, which are characteristics protected under IHRA that include examples such as sex, religion, race, and it's harassment based on these traits is what triggers legal protection. Unlawful conduct meets the legal threshold under IHRA if it is severe or pervasive, unwelcome, and or based on sex. And inappropriate behavior is rude, offensive, or unprofessional, but may not rise to the legal standard of harassment. This section covers the two legal forms of sexual harassment, which include quid pro quo and hostile work environment, and the critical topic of retaliation. There are two forms of unlawful sexual harassment. The first column details quid pro quo, which is basically this for that. It is illegal under both federal law and state law. And quid pro quo occurs when a person in authority makes submission to sexual conduct a condition of employment, either explicitly or implied, or uses acceptance or rejection as a basis for job decisions. It only requires one incident to be considered unlawful harassment, and the harasser is typically a supervisor, manager, or employer. The other form, hostile work environment, must be severe or pervasive. It too is illegal under both federal law and state law and occurs when unwelcome sexual conduct is so severe or pervasive that it interferes with your ability to do your job, and it makes the workplace feel intimidating, offensive, or abusive. However, unlike quid pro quo, the harasser does not have to be a supervisor. So here are a couple concrete examples of quid pro quo harassment. What do these all have in common? They all involve a person in authority using that authority to condition job benefits or decisions on sexual compliance. I want to emphasize that the exchange does not have to be explicit. An implied threat or promise is sufficient. Anyone can be a victim of quid pro quo harassment. Harassment law is gender neutral, so a female supervisor can harass a male employee. A same-sex harassment scenario is also equally protected. All workers under Illinois law, including full-time, part-time, temporary, and contractors are protected. Just as important as what quid pro quo is what it's not. It's not a mutual consensual relationship between coworkers of equal standing. However, be cautious about the supervisor-subordinate relationships, because even the consensual ones do carry a legal risk because of the power imbalance. Hostile work environments are the second legal form of unlawful sexual harassment. This includes unwelcome conduct of a sexual nature that is severe or pervasive enough to affect your work, creates an intimidating, hostile, or offensive work environment, and in which a reasonable person would find offensive or abusive. The reasonable person standard is important because courts ask whether a reasonable person in the victim's position would find the environment abusive, not just whether the individual victim found it offensive. Courts also look at the totality of circumstances, meaning all relevant conduct over time is considered together. Other factors courts consider when evaluating whether conduct is severe or pervasive include its frequency, severity, whether there's a physical threat present, if the person is humiliated, or if it interferes with job performance. And again, courts look at the full picture. One assault at the extreme end of severity can qualify on its own, but repeated mild conduct over months can also qualify, even if each individual act seemed minor. Here are a few examples you may have encountered in any of your professional experiences, such as repeated sexual jokes or comments, displaying explicit videos, posters, sending explicit emails, text messages, offensive comments about other people's body or appearance. These behaviors, even if dismissed as just jokes, can still create legal liability. An important point is that the harasser does not have to be a supervisor. Coworkers, customers, vendors, and non-employees can all create a hostile work environment. And when the employer knows about it and fails to act, the employer can be held liable. It's also important to note that bystanders who observe the harassment and find it offensive may also have claims. Just as with quid pro quo, let's clarify what does not constitute a hostile work environment. So examples include a single offhand comment, ordinary workplace rudeness, welcome banter between coworkers, or legitimate performance feedback. But a caution that still the context and the pattern still matter, and seemingly minor incidents can compound over time. So let's consider each of these scenarios. In scenario A, a manager tells an employee that a promotion depends on going on a date with them. In B, a coworker repeatedly shares sexually explicit jokes through email despite being asked to stop. And C, a customer repeatedly makes comments about an employee's appearance and body during their visits. So out of these scenarios, scenario A is a classic quid pro quo. And remember that with quid pro quo, one incident is sufficient. Scenario B, possibly. And that's because repeated conduct after an objection to it can establish hostile work environment claims, but the full pattern still matters. Scenario C is unlawful harassment. Illinois law covers third-party harassers, and the employer must take a corrective action even when the harasser is a customer. Retaliation is one of the most important and frequently misunderstood topics in harassment law. But retaliation is independently illegal, and that means an employer can be found liable for retaliation even if the underlying harassment claim is not proven. Retaliation is also consistently the most frequently filed charge with the EEOC nationwide. There are a range of protected activities from retaliation, but the critical point here is the last bullet. Protection applies even if the underlying complaint is later found to be unsubstantiated. As long as the employee had a reasonable good faith belief that what they reported was harassment, they're still protected. What does retaliation look like? Obvious forms of retaliation are often easier to identify. So, for example, termination following a harassment complaint is actually one of the most commonly litigated forms. As you're looking through this, consider each one of these examples and think about, would a reasonable person see this as punishment for reporting sexual harassment? Subtle forms of retaliation are harder to prove, but equally illegal. Negative performance reviews that suddenly appear after years of positive reviews, schedule changes causing hardship, exclusion from team meetings, or social isolation can all constitute retaliation. Employers have to monitor for these patterns after an employee reports harassment. So we're going to investigate this case of Lisa. Lisa's a 28-year-old pharmacist that works at a very busy retail pharmacy in the Chicago suburbs. She just recently joined the pharmacy team after graduating from pharmacy school. Her team consists of herself, 3 male pharmacy technicians, 1 other female pharmacy technician, and a pharmacy manager named Greg. So shortly after Lisa starts her role, the following starts to occur. 2 male pharmacy technicians, Kevin and Troy, regularly make comments while working at the dispensing counter, such as, "We finally got a pharmacist worth looking at," and "You're way too hot to be stuck behind the counter." Kevin frequently stands unnecessarily close to Lisa while she's verifying prescriptions, brushing against her in the narrow workspace behind the counter. Troy sends Lisa messages that contain sexual jokes on WhatsApp after getting her number from the work group chat. When a male customer is rude to Lisa, Kevin and Troy laugh and comment, "Maybe if you smiled more, he would have liked you better." So Lisa approaches Greg, the pharmacy manager, on 2 separate occasions to report the behavior. Greg responds by saying, "Kevin and Troy are just joking around. That's how they keep things light during busy shifts." Or, "You're new here. You'll get used to the way that we do things." And, "I don't want drama at the counter. We have prescriptions to fill." Greg takes no corrective action. He does not document Lisa's complaints, doesn't speak to Kevin or Troy, and does not notify HR. The behaviors continue and intensify over the following weeks. So Lisa begins to dread going to work and experiences anxiety before her shifts. She's having difficulty concentrating due to the ongoing comments and distractions, and even avoids the break room. After about 8 weeks of ongoing harassment and no management response, Lisa begins documenting all incidents in a personal log with dates, times, locations, and witnesses. She files a formal written complaint with the company's HR department, bypassing Greg. When HR conducts only a minimal review and takes no meaningful action, Lisa files a complaint with IDHR and consults with an attorney specializing in workplace harassment. So what type of scenario is illustrated here? Is it A, quid pro quo because Lisa was denied a promotion? B, hostile work environment because the ongoing sexual conduct made her workplace intimidating and offensive? C, retaliatory harassment because Greg disagreed with Lisa's work performance? Or D, constructive discharge because Lisa was formally terminated from her position? Answer B is correct. This is an example of a hostile work environment case. The ongoing sexual conduct from coworkers interfered with her work and made her environment intimidating and offensive. There were no job-related threats that were made, which rules out the quid pro quo. And Greg's dismissiveness was not retaliatory harassment, but it was a failure to act. Lisa was not formally terminated, ruling out constructive discharge. This section covers the practical reporting process, anti-retaliation protections, and remedies available to victims of sexual harassment. So why does reporting matter? Many victims of harassment don't report because they fear retaliation, not being believed, or consequences to their careers. I want to emphasize that reporting is legally protected. It also creates a record and it triggers the employer's legal obligation to act. In addition, remaining silent can allow harassment to continue and harm other people. There's a two-track system that offers protection. We have the federal level through EEOC and Title VII, and then the state level in Illinois with IHRA and IDHR. Both of these protections can apply simultaneously, and filing with one does not waive the right to file with the other. So this dual track system is a significant advantage for Illinois employees compared to employees in states without a strong Human Rights Act. The first step is internal reporting, and this is because employees are generally expected to attempt internal reporting first, unless the harasser is the HR director or the owner. Internal reporting puts the employer on legal notice and it triggers their obligation to investigate and act. There are some best practices for internal reporting, which include always use written communication, whether it's email, a formal complaint form, or a letter. Keep copies and document what was said and when. Internal reporting, again, creates the paper trail that becomes critical if you decide to later escalate to an agency or file a lawsuit. So what happens if internal reporting fails? Internal reporting is not always required or safe. Again, if the complaint is about a person in power over the HR process, or if there's retaliation, or if the complaint is ignored, employees can and should escalate directly to either IDHR or EEOC. This comparison chart for EEOC and IDHR filings summarizes coverage and filing process. But there are a few key differences here. With EEOC, it's employers with 15 or more employees versus IDHR, which covers all employers, even with only one employee. The filing deadline is 300 days under IDHR. Now, typically it's 180 days with EEOC, but under provisions, it's extended to 300 days because Illinois also has that 300-day requirement. There's multiple filing options that are available for both of these agencies. And in Illinois, the IDHR is often the most accessible and broader coverage option. Post-filing, the employer is notified, the EEOC investigates, and if no resolution is reached, the complainant receives a right to sue letter, which is a prerequisite for filing a federal civil lawsuit. However, the process for a federal lawsuit can take months or years, and the EEOC's mediation option is often much faster and a voluntary alternative. After filing with the IDHR, their process is a bit different. They'll first investigate to determine if there's substantial evidence, and if found, the case moves on to the Illinois Human Rights Commission for a hearing, or the complainant may elect to file in circuit court. If substantial evidence is not found, the complainant may appeal the decision. Illinois also provides an alternative court pathway for stronger cases. There are a range of remedies that are available to victims of sexual harassment. These go beyond just damages. They can include workplace policy changes, reinstatement, back pay, removal or reassignment of perpetrators, and attorney's fees in some cases. The remedies exist to make victims whole and to change the conditions that allowed the harassment to occur. So let's explore this case scenario with Victor. Victor's a first-year pharmacy resident at a hospital-based pharmacy program in Chicago, Illinois. His preceptor, Dr. Shields, is a senior clinical pharmacist who's supervised residents for over 10 years and holds significant influence over Victor's evaluations, rotation grades, and future career recommendations. Over the past 6 weeks, his preceptor has engaged in the following behaviors: repeatedly commenting on his physical appearance during rounds, sends him text messages asking him to stay late, just the two of them under the guise of extra training, and stands unnecessarily close to him and frequently places her hand on his shoulder or arm without invitation. When Victor politely distances himself, his preceptor gives him lower scores on his rotation evaluations and makes comments such as, "You're not demonstrating the level of commitment I expect from my residents." She has told him privately that his evaluation scores, which directly affect his ability to complete the residency program, will improve if he shows more personal investment in their working relationship. Victor feels confused and uncomfortable. He has not reported the behavior because he fears his preceptor will give him failing evaluations, which could end his residency and damage his pharmacy career before it begins. He also worries that no one will believe him because Dr. Shields is a well-respected senior clinician and he is a male resident being harassed by a female preceptor. Which of the following statements best describes the legal nature of Dr. Shields' conduct towards Victor? A, this is not sexual harassment because Dr. Shields is a woman and Victor is a man. B, this situation only qualifies as a hostile work environment because there is no direct threat to Victor's employment status. C, Dr. Shields' conduct constitutes both quid pro quo and hostile work environment under both federal and Illinois state law. Or D, Victor cannot file a complaint because he's a resident and not a full-time employee. So answer C is correct. And let's walk through all the other misconceptions. For A, gender is irrelevant. Harassment law is gender neutral. With B, both types are present. Quid pro quo in the evaluation threats and hostile work environment in the ongoing unwanted contact and comments. And then B, stating Victor cannot file is incorrect because residents and interns are explicitly covered under Illinois law. Let's transition by connecting statutory requirements to employer policies. Employers must translate legal obligations into accessible, operationalized policies within their institutions. The policies can't just exist. They must be communicated and understood by all staff. There are some pharmacy-specific contexts to this. Recall that power imbalances can exist between pharmacists, technicians, students, and residents, and create real barriers to reporting. In addition, patient-initiated harassment is also covered under IHRA's places of public accommodation provisions. So that is still covered by employer responsibility. Smaller isolated pharmacies may also have fewer reporting options. However, employers must still provide accessible, safe pathways to report. Here are some key takeaways for this section. First, federal and state laws provide distinct complementary protections. Victims have multiple reporting pathways and very strong anti-retaliation rights. And understanding the statutory frameworks supports safe, compliant environments. In the final section, we're going to discuss employer responsibilities. Employers have legal obligation to prevent, train, investigate, and remediate sexual harassment claims. And the overall organization has liabilities. In pharmacy and healthcare settings, more vigilance is typically required because of the power differentials that are inherent in the training and supervisory structures. Again, Illinois mandates training to ensure that all staff at all levels understand their rights and responsibilities. Under Title VII and EEOC guidance, an effective prevention program requires an explicit written policy, regular communication of that policy, training for all employees, and a complaint procedure that does not require the victim to confront or first report to the harasser. These are the baseline standards. The IHRA imposes additional specific requirements. The EEOC standard for reasonable care goes beyond having just policy on paper. Employers must actually train employees and implement the policy effectively. A policy that exists but is never communicated or enforced provides little legal protection, and training must equip supervisors specifically with skills to prevent, identify, stop, report, and correct harassment. This slide details the IHRA specific mandate for the state of Illinois. Every Illinois employer, even one with a single employee, must provide annual sexual harassment prevention training. Training must reach all employees, including part-time, short-term, and interns. New employees must be trained within 6 months of hire, and new supervisors also within 6 months of assuming a supervisory role. Required elements of the Illinois compliant training include employer responsibilities and prevention, investigation, and corrective action. This will have an explanation of what sexual harassment is, examples of conduct that constitutes unlawful harassment, and a summary of the federal and state laws that concern harassment. It should also include the remedies that are available to victims and list the employer responsibilities. Employers must also maintain multiple accessible reporting pathways. Not all employees are going to be comfortable reporting to their direct supervisor, especially if that person is the harasser or is close to the harasser. Anonymous reporting mechanisms, HR hotlines, and alternative escalation paths are all important. Illinois has specific record-keeping requirements. Employers must be able to demonstrate that all employees receive compliant training, and the employer, not the employee, is responsible for verifying that the training is compliant. If an employee claims they received training elsewhere, the employer must obtain documentation and verify that it meets the IHRA standards. This slide consolidates the investigation and corrective action duties side by side. In the first column for investigation duties, employers must investigate all complaints promptly and thoroughly, use neutral trained investigators. They must also interview the complainant, respondent, and any witnesses. They must maintain confidentiality to the extent possible, document all steps and findings in writing, and reach a reasonable factual conclusion. In this case, prompt means as soon as possible, because delays can result in continued harm and increased liability. The second column with corrective action duties for employers include prompt proportionate corrective actions, discipline up to and including termination, remediation of the victim's working conditions, monitoring for recurrence after actions are taken, again, documenting all corrective measures, and ensuring that there is no retaliation. Retaliation protection is a non-negotiable and runs throughout the entire employer response process. This includes from the moment a complaint is received through investigation, corrective action, and beyond. Employers must also actively monitor for subtle retaliation like schedule changes, isolation, or exclusion, and document the anti-retaliation measures that they take. Managers and supervisors are held to a higher standard than regular employees. This slide is detailing the manager and supervisor responsibilities. This includes mandatory reporting. So any managers or supervisors must report any harassment they witness themselves or any harassment they learn about, even if the victim does not want to file a complaint. They should model appropriate behavior and exemplify respective conduct. because they set the tone for workplace culture and are ultimately held accountable for the team environment. Managers and supervisors must cooperate with investigations, internal or external, and maintain strict confidentiality throughout. They cannot have any tolerance for retaliations, even subtle retaliations. And again, retaliations are protected through several mechanisms. So any exposure to retaliation also exposes the employer to independent liability. Managers and supervisors have an intermediary role. They must connect the complainants to HR and make sure that the complaint is documented and forwarded to the appropriate party promptly. And they also have liability exposure because failure to act on a known harassment may result in personal liability and employer liability under Illinois law. Here's a list of some common employer failures or what not to do. These are the actions or inactions that can result in successful harassment lawsuits and agency findings and include delayed or incomplete investigations, minimizing or dismissing complaints, requiring staff to confront the alleged harassers directly, failing to protect confidentiality or prevent retaliation, or not documenting findings or corrective actions that were taken. So key takeaways from this section include employers have clear legal obligations for prevention, reporting pathways, investigation, and corrective actions. Staff awareness strengthens organizational compliance. And a transparent, consistent response process protects patients, employees, and the overall organization. So let's stop and reflect on employer responsibilities. Which of the following best describes an employer's complete legal obligation under the Illinois Human Rights Act when an employee reports sexual harassment? A, inform the accused employee of the complaint and allow them to respond in writing before taking any action. B, investigate the complaint promptly and thoroughly, take proportionate corrective action, protect the complainant from retaliation, and document all steps taken. C, encourage the complainant and the accused to resolve the issue informally before initiating a formal investigation. Or D, report the complaint directly to the Illinois Department of Human Rights within 30 days of receipt. The correct answer is B. The reason for this is that under both IHRA and EEOC guidance, employers are required to do all four things when a harassment complaint is received. First, they have to investigate promptly and thoroughly using a neutral investigator. Second, they need to take corrective action that is proportionate to the severity of the conduct. Third, they need to protect the complainant and any witnesses from retaliation, which again is independently illegal. And finally, they need to document every step of the process. So answer A is incorrect because the investigation process involves interviewing all parties, not simply forwarding a complaint to the accused. Answer C is incorrect because requiring or encouraging direct confrontation between the complainant and accused is explicitly identified as an employer failure under both federal and Illinois law. And answer D is incorrect because there is no 30-day mandatory reporting requirement to the IDHR. The IDHR is the agency employees file with, not employers. So in summary of this activity, Illinois defines sexual harassment broadly, and it covers all employers, all protected categories, and both unlawful conduct and inappropriate behavior must be distinguished. Unlawful harassment can take two forms: quid pro quo, where one incident is sufficient, and hostile work environment that is severe or pervasive. Both verbal and nonverbal conduct qualify. Victims have dual track options. They can file with the IDHR 300 days post, or the EEOC within the state of Illinois, also 300 days post. Illinois law is broader than federal law, and retaliation for reporting is independently unlawful. And finally, employers must have a written policy, deliver annual training, and investigate all complaints promptly. They must also take proportionate corrective action and prevent any retaliation. That concludes this presentation for sexual harassment prevention. Thank you for your time and attention over this important topic.